Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Hello everyone and welcome back to another live stream with me, Grizzly K. This is Grizzly True Crime. Just hold on, sorry, I'm getting the chat going for us. And we are looking at day 4 of the Megan Imirowicz case. Let's do it like that. Okay. Let's test it out. Let's see. Yes, hello. Okay. Please do like, share, hashtag Megan Imirowicz so that others know that we are live. I went live a little earlier than when I changed the time because I have managed to kind of clean up a bit of that static from that body cam. I also found this article from Oxygen, which kind of changes everything on day 4. They say a Michigan teenager is facing upgraded charges of murder after her father succumbed to injuries. Okay, so there are murder charges on the table then. See, they didn't stream day 1 with all the fluff, you know, of like when the judge is talking and what they're saying and what the charges are and bring them in, all that. So, and it's very hard to get these documents, right? But here, that's new to me. Okay, so all those charges we're looking at, valid, the DV, the misdemeanor, causing the death, a felony, sure, but they say upgraded charges of murder. Megan Joyce Imirowicz, 18, had initially been facing charges of assault with intent to do great bodily harm, less than murder for the alleged October 1st attack. This was in 2021. But the charges were upgraded by Oakland County Prosecutor's Office after the 64-year-old died from his injuries on March 6th. So it was on March 6th that the charges were upgraded. Okay, so we gotta consider all the facts as we look at it. I wonder if she'll testify today. Imirowicz has been accused of throwing a mixture of lye powder, often used in drain cleaner, and water at her father. So she did say that on that body cam, which we're going to look at, okay? And yeah, they never mentioned this. It makes me so mad, right? So, they never mentioned that, and I just found this now. Interesting. And so, they say she's been accused of throwing a mixture of lye powder, often used in drain cleaner, and water at her father at their Groveland Township home on October 1st, causing chemical burns on his head, torso, and extremities. Police say the teenager then left her father unconscious at their home. He was later found by a neighbor with burns all over his body. Investigators discovered lye powder on the couch at the home. Imirowicz was identified as the suspect in the attack after Michigan State Police spoke with her father, who has not been publicly identified. At a hospital in Grand Blanc. Authorities have not released a possible motive for the attack. The Michigan State Police referred Oxygen.com to the county prosecutor's office, who did not immediately respond to a request for the additional details on the allegations. So that's what we have. This article was published in March 16th, 2022. So everything that I read from Court TV, and from Law and Crime Network and everything that it's the charges we've known about all along, but I'm like, wait, what? There's one here, and there's one on People as well. So, there's that as well. Caroline, thanks for being a member for 11 months. And Chopper says, if you own lye in your home, I'm not coming over. Okay, wait, I'm going to monitor the stream. They say they're starting at 8 minutes. So what I've done, let me just get it for you. Just like this, is try my best to clean up the audio of that body cam. So I'm going to play it for you.
Is this that video, sir?
Correct. It records at 30 seconds, just for your knowledge.
Media. There we go.
Yes, sir. I don't know. What's your name by chance?
Chloe.
Chloe what?
Hour.
Do you got any friends in here named Megan?
Yeah.
Yeah, it's alright there. You mind stepping out and talking to me for a minute? How are you?
Good.
You got any weapons on you?
No.
Okay, we're just gonna go talk about it in front of my car, okay? Okay. You You know why we're here?
No.
You don't know?
About my dad?
Yeah. So we're just making sure, making sure he's okay. We talked to right over in front of this car. He's actually at the hospital right now. So I don't know if you know that or not. So do you know why we're here?
I know that they told me that he has some kind of burn mark.
So
I'm just going to stop this for a moment. Trooper, who's that in the center of the frame?
That'd be Megan Imirowicz.
Sorry, I'm here on the side. I'm trying to size it nicely for you, so that you could see it nicely and hear it nicely. But I'm just going to put the thing on the screen for you to watch, okay? There we go. And then as soon as the trial's back, I'll play it. Okay, here we go. Hope you can hear it.
Okay, that's this person here I'm indicating with my cursor.
Correct.
And who is this with my cursor?
That'd be myself.
And who's over here?
That'd be Trooper Corona.
And right here.
Trooper Baldwin.
Okay.
when was the last time you were at the house?
Around 10. I left around 2:30 maybe.
Okay. And right now you're not in trouble, you're not under arrest. I'm just seeing what happened, okay? We got a couple stories from Austin, and a couple other people. So we're getting your story, okay? So in greater detail, what happened today? So you left at 10 o'clock.
Jason DeSantis from the People, Your Honor. Good morning.
We'll look at it later again.
Mr. Imirowicz, who's not quite up yet.
Thank you.
Good morning, Hunter Smith.
Thank you. Mr. Miller, sir, anything that you want to state for the record?
My client and I have talked. I've talked to my witnesses. I want to make sure my client will waive her right to testify when she gets up, and we will not present any witnesses this morning.
Oh my gosh.
Okay, so you're ready to proceed into closing arguments?
People are.
I can be, yes.
Okay, and then with regard to the final jury instructions, are there any changes?
There would be one or two things that would have to come out, I think.
Yeah, I think there were a couple changes that I don't know.
My final jury instructions have a 3.01, 3.2, 3.3, 3.5, 3.6, 3.10, 4.01, 4.03, 4.05, 4.06,
This court, oh my word, it's just like no other witnesses, waiving a right to
judicial
testify.
notice of anything, Judge.
Correct.
407,
Any facts, really.
No, we really did.
So I take that out as well.
Thank you so much,
stipulation
James.
to something.
There was some to admission of some exhibits,
Right, exhibits.
but there wasn't actual to facts.
I think there was with regard to him being intoxicated on the.
That's fine.
You want it in or out?
It's
407?
not going to.
It's not going to matter.
I don't think it matters. Yeah, it's fine. We can leave it.
409,
So, welcome to day 4, everyone.
502, 503, 508.
I don't think there's anything for 508. Character evidence or credibility of a witness.
I think so either.
I think we could take 508 out, Judge.
510,
There was, but it would only just be Dr. Virani, so that would be the only person to list there.
This attorney, I wonder what the
And-
jury's going to say.
Virani.
first name.
Kanu,
A-N-U.
K-A-N-U.
A.
K-A-N-U.
Okay, and what was the pathology?
We'll watch that body cam
Forensic
again
pathology, yes.
afterwards, okay?
$511,
Fine.
$723,
That, I think, would come out.
$3903,
Of course, it stays.
172A,
Here. Yeah. It's fine.
311,
It's fine.
313,
Good.
314,
Fine.
Good.
315,
Good.
That's fine.
316,
That's fine.
Good.
319,
That's right.
323,
That's right.
and the verdict form. Anything else?
Satisfied, Judge.
Satisfied.
Thank you.
So the defense has rested their case.
We'll take these 3 pages out. Final verdict form.
Wow. What do you think is going to happen, you guys?
For the final verdict form. Should have done that. Final verdict form that you guys have stipulated to.
So we're going to get closing arguments now, I assume. Closing arguments, and then the jury will deliberate. Sorry, I'm fixing the border. It's day 4. Yeah, they got to do closing arguments. Gemini says hung jury. Imagine.
As you know, the jury only gets one copy of the verdict form. This is the final verdict form that was submitted to the court. You can present this to the lawyers, please, Ms. Joyce.
Yeah, she's not in court.
The final verdict form.
The defendant is not in court from what I can see at this point. What a trial. Oh my word. This one has been very interesting.
Mr. Miller? I'm satisfied. Thank you, sir. This should go with the final verdict form then. Okay, so now we're waiting on Ms. Imirowicz. I'm not sure what the delay is.
I know there's a criminal call, and I know there's a trial starting next door.
Good, they're waiting for the defendant. They don't know what the delay is. Wow. Her mom's in the back there. Let me show you quickly. Here's her mom. Sure.
Okay, I'm going to step off the bench until she gets here. Before the jury comes in, I will have you question your client, Mr. Miller, with regard to whether or not she's waiving her Fifth Amendment right to remain silent, or whether she wants to willingly, knowingly, and voluntarily take the stand. So we'll proceed in that fashion as soon as your client arrives. Okay?
All right.
Thank you, everyone.
Thank you.
Please rise.
Oh my gosh. Okay, so back to the body cam. Back to the body cam, guys, because what in the hell was that? Okay, let's take this off. You want to see the body cam again? I'll monitor the court. Okay, so the defense has rested their case. They say that Megan will not be testifying, is what I understood. And now it means closing arguments, and then the jury will be deliberating, I guess. I wonder how long this verdict will take. If I was on the jury, this is a hectic one. Oh my gosh. Especially now with the upgraded charges as well, to think about that. If you missed that, we read a March article from Oxygen that says the charges were upgraded to murder, and I saw one article that said open murder. So I added it to my banner there as well. Laurie says, is Megan in custody so they bring her? I think so. It looks like it. Seems so. Okay, so let's go back to the... Where is my... There we go. This one. Okay. Let me try and make it nice for you. So what I've done here is clean up the sound as much as possible. And it did improve. I must say, it did improve. So let's see what we can hear from it. How about that? Okay. Yeah, Joe Kelly says, Internet, the witnesses are all gone. Nobody left to question. Because it's all up to whatever people on the jury want to think, all on their own. Wow. Okay, let me put that chat on top there. So, here we go. Let's watch it again. Let's hope they don't interrupt us this time, right?
Is this that video, sir? Correct. It records at 30 seconds, just for your knowledge. Right here. Trooper Baldwin. Okay.
When was the last time you were at that house?
Around 10. I left around 2:30 maybe.
Okay. And right now you're not in trouble, you're not under arrest. I'm just seeing what happened, okay? We got a couple stories from Austin, and a couple other people. So we're getting your story, okay?
yelling at him behind, because obviously that's been a hard thing, you know, because
Absolutely.
he's not drinking and it breaks my heart.
Absolutely, it's tough. I totally understand.
And I just kind of got mad. I know, like, all I threw at him was a bag of bread. And I know that didn't hurt him because it's a bag of bread. But I got upset. I went to go pack my stuff because Cody was coming to get me and bring me here. And then I went to the bank because I had to, his credit card wasn't working. And that's what we paid under. So I went to the bank and everything. And I asked my friend Kayla to go over to my house so we could, she could ask my dad's phone number so I could remember it. And that's when she like told me like, I don't think he's okay, like something's wrong with him. And I was like, trying to ask me what was happening, like what was going on. I don't know. And then my brother texted me and was like, Megan, when Kayla's done calling in ambulance, tell her to call me back. And then I told her and she called him. And then they all just started, like, my mom called me and she was like, Megan, did you do this to your dad? I was like, no, I didn't. I would never intentionally hurt my own father, and I'm such that they don't think I would. But I could never do that to him. I didn't. Like, there's a lot of stuff over in that area, so it could have been over there. Since our house is a mess, it could never
What could have been over there?
they said chemical work, so I don't know. But my dad does a lot of stuff over there. I don't clean it up because I shouldn't have to be the adult mom.
Right. I totally get where you're coming from. Is there anyone else in the house?
Just me and my dad. My brother comes back every other week.
Okay. So I'm gonna be honest with you. Your dad's in bad shape. So there's a lot of burning on your dad. Okay. Consistent with chemicals, right? You said you were fighting with your dad. That's fine. You know, I totally understand. If he's drinking, that's absolutely not how we should be running his household. Totally understand that. You know. But it's just not, I'm not understanding. Is this self-inflicted? Like, if you, I mean, put you in my shoes. You two are the only people in that house. And you leave at 2 o'clock and he's perfectly fine, right? And all of a sudden, he's,
I get that.
you know what I mean? So, how does he get these, you know?
I mean, we have stuff over there. We have cats that knock things over all the time. It could have been them. I don't know. If I knew that there was chemicals over there, I would have cleaned up. But I didn't know.
You remember me? Remember I talked to you in the my mom, right? Okay. So, yeah, I was there in the house, right? I understand the whole situation that got going on. Last time I tried to talk to you, barely even sit up, so I understand the anger and the upset and stuff you would have to do this stuff. Okay? Now, we went over to the house today. Okay? So, we were also told by some of your other friends that you told them that you regret and how it happened.
I never do cleaning on their food. Maybe like I do like food. There's only ever food around there. I would never intentionally throw something dangerous out my own father.
Right? Why? So, you found the 20 bucks, I was just like, oh, well. Now, here's the thing. Here's what makes sense, right? You just throw a piece of bread at him, and all the things burned up. That doesn't make sense. It doesn't make sense. You just grab the things, like, on the stack, you're throwing it at him,
And we have to stop again. Sorry. So annoying. Okay, but let's watch what's going on in court. So we'll take this one off.
Count 1 said unlawful use is unlawful use causing death. I asked Mr. Miller about it. We're agreed that that's what it should be.
Yes.
So you want it just to say unlawful use?
No.
We want to say what it says exactly right there.
I'm going to go back a few seconds.
That's
They amended it. They should have printed a new one out.
Guilty.
I went just back a few seconds.
Thank
We
you.
need to hear this.
More in your outer hunters.
Thank you. Megan Imirowicz. Ma'am. I just received a change of the verdict form.
That's right, Judge. We just realized that the verdict form actually said chemical. Count 1 said unlawful use is unlawful use causing death. I asked Mr. Miller about it. We're agreed that that's what it should be.
Yes.
So you want it just to say unlawful use?
No.
We want to say what it says exactly right there.
Unlawful use causing death.
That's
They
correct.
amended it. They should have printed a new one out.
Guilty of chemical irritants, unlawful use causing death.
Thank you. I have it. And then in the chemical irritants at the top in bold, Did you want that in causing death as well?
It should be, yes.
All right, so you want to make that change?
I will.
Thank you. Hold on a minute. Thank you. With regard to testifying,
Your Honor, I talked to my client. It's my understanding that my client will waive her right to testify. And I would like to question her on that.
Ms. Imirowicz, ma'am, can you stand up and raise your right hand to be sworn, please?
I would like to question her on that.
Under
Wow.
penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give this court today is the truth, the whole truth, and nothing but the truth?
Okay.
Go
Okay.
ahead, Mr. Miller.
Thank you. Would you state your name and spell your last name for the record, please?
Megan Imirowicz, MeganImirowicz.
It's getting spicy.
Mr. Imirowicz, you and I have had the opportunity to talk about your testimony, correct?
Yes,
I've explained to you you've got an absolute right not to testify. You understand that?
yes,
You also can testify if you want to.
yes.
All right. Now, it's your intention at this point in time to invoke your Fifth Amendment right and not testify, correct? All right. And that's what you want to do.
Yes.
Thank you.
Okay. With regard to the verdict form,
It's
you've
been-
sent that over?
I have, Judge.
Okay, I'd like that framed, and I would like the lawyers to both look at it to make sure that's exactly how they want it. And then, you're not calling any further witnesses,
I'm
is
not
that
calling any
correct?
further witnesses, correct?
Okay, so the defense is resting at this time.
Yes.
Okay, and Ms. Imirowicz, it's your indication on the record, ma'am, that you do not wish to put a defense on with regard to your own testimony, and that you're invoking your Fifth Amendment right to remain silent. Is that correct, ma'am?
Yes.
Okay, ma'am.
People won't be calling any rebuttal witnesses, Judge.
And there's no rebuttal witnesses. Okay.
Shame. Yeah, she looks very confused.
Yeah, it's not.
It's not correct. Okay, well.
It didn't say
Make a change.
Yeah, it's just the top. It should say causing death there. Apparently it didn't say the place.
Well, actually, you sent another one at 9:44.
One I just sent. Maybe it didn't come in time.
Is that it?
I think she should have testified. What do you guys think? Shame.
Why don't we approach and take a look at it?
Okay.
Satisfied.
Thank you.
I'm sorry.
Okay, we're ready for the jury.
Amy K says, seems like she wanted to, sad. If I haven't yet said this, welcome to all my moderators, to all my patrons, members, new subscribers, welcome. There's lots of new subscribers. Welcome to the channel, welcome to the community, and to the OGs, original Grizzlies. We are on day 4 of the Megan Imirowicz trial. She's 19 years old, and she's charged with unlawful possession or use of harmful
seated,
devices or irritants causing death or
Ladies and
felony.
gentlemen, we have called the case. We are on the record. Attorneys have put their appearances on. Mr. Miller, sir?
Your Honor, defense rests. We have no witnesses to present.
Thank you. And Mr. DeSantis, any rebuttal witnesses?
No rebuttal witnesses, Judge.
Okay, thank you. Ladies and gentlemen, all the proofs are in. Both parties have rested. The plaintiff, the people, will now present their closing argument to the jurors. You may move the podium if you need to.
I'm actually going to stay here if I can use the screen, please.
Sure.
Thank you, Judge. morning, everyone. Thank you again for your time and attention. This has been a long trial, and it's been a little bit disjointed. I acknowledge that. It couldn't be helped, I'm afraid. Now, this is going to be the part of this trial where I go over everything I presented and give you all those little puzzle pieces again that I talked about in my opening and help you put them together. So I want to start by talking about our burden of proof. This is my standard. A reasonable doubt is a fair and honest doubt, growing out of the evidence or lack of evidence. It is not merely an imaginary possible doubt, but a doubt based on reason and common sense. It's also not beyond any doubt or beyond all doubts. And we don't have to conclusively disprove any alternative theory because that would be impossible. It's always possible you can have 99.999% of a picture set, and that there's always, that little tiny 0.0001% chance that could come and screw it up. But that's not a reasonable doubt, right? It makes me think sometimes of when we put in DNA evidence. The lab techs always say it's something like a 1 in 100 billion chance the DNA on the murder weapon comes from someone other than the defendant, right? They don't say, yeah, it's the defendant's blood. They just say it's almost impossible for it not to be. Okay? That's kind of what we're talking about here. It's possible, but it's not reasonable. In a case like this, I think the greatest assault you can make on the case we put on and the reasonable doubt here would be one of distraction. It's one that would get everyone on the jury, all of you, to miss the forest for a single tree. A pine forest is still a pine forest, even if there's another tree in it. I want to talk a little bit about the inferences. They are not only allowed, they are required. This is something that we do every day, and it's something that jurors have to do as well, because very, very rarely does a defendant stand in front of people and tell them exactly why they committed the crime and what their intent was when they did it. And if they do, those cases even more rarely go to trial. An example I like to give is if you come downstairs in the middle of the night and you see your kid with his hand in the cookie jar. You know exactly what he's doing, right? He's getting a cookie. It's possible he could be doing something else with it, but it's not reasonable. He put his hand in the cookie jar because he's getting a cookie. There's no other rationale for it. Now, before we really dive into everything and I go over some of the evidence again with you, I want to remind you that two of the elements I do have to prove are the date and the venue. So the date in this case, of course, on or about October 1st, 2021, and the venue is Oakland County. I don't really think that's been disputed in this case, but I need to say it anyway. When I started, I told you that trials are a quest to determine what happened and if what happened broke the law, and it's your decision on those two things. That's your job. Everything else is for somebody else. So let's go over that now. Let's apply the facts to the elements. What happened? Here's the basics, I think, about what happened actually on October 1st, 2021, and what I think the evidence shows. It's Megan's birthday party. Life has not been easy necessarily at the Imirowicz household, and today is going to be a good day because it's her birthday party. So she gets up, she goes to get her dad to drive her to her hair appointment, and Dad, Konrad, is drunk. Probably again, right? This is not going to be the first time, and that's really not okay. Not today, not on this day, and she loses control. She starts throwing things at him. It's not helping her feel better. She's furious, out of control, and she goes way, way too far. And that's something that can happen to all of us. When we lose our temper, we can go too far. And so she grabs the lye, pours it on him, and pours water on him. A couple of hours later, Kayla finds him burned when Megan sends her over there to get the credit card number. She calls 911. Conrad's taken to the hospital, and after months of treatment and pain, he eventually dies from the burns and the complications thereof. That's the basics. So how do we know? Did it break the law? We have to apply the evidence to the elements. These are the elements of the offense. Unlawful possession or use of chemical irritants causing death. The defendant placed, used, or released a substance. The substance that the defendant possessed, placed, used, or released was a chemical irritant, which is a solid, liquid, or gas that through its chemical properties, chemical or physical properties, alone or in combination with one or more other substances, can be used to produce an irritant effect in humans, animals, or plants. The defendant possessed, placed, used, or released the chemical irritant to frighten, terrorize, intimidate, threaten, harass, injure, assault, batter, or kill Konrad Imirowicz, and that the possession, placement, use, or release of the chemical irritant resulted in the death of Konrad Imirowicz. Let's take them each in turn. Facts and inferences apply to element 1. Placed, use, or release of substance. This case actually differs from some homicides where we actually do have some statements from the victim to people. In his opening, Mr. Miller said that in this trial you would not find in any exhibit testimony, or even in, I think he said like the 20,000 some pages of medical records, you would not find a single instance where Konrad said that Megan threw chemicals on him. That found out to be not true very quickly.
1, what's the location of the emergency? This is Oakland County with a transfer at 1650 Duck Creek Lane. Okay, thank you. Hi, caller, what's going on out there?
Hi, my name is David. I'm a nurse at Ascension Genesis in Grand Blanc, Michigan, calling to report a possible assault on my patient.
Okay.
My patient's name is Konrad, Konrad. Last is Imirowicz. He's a 64-year-old male patient with a date of birth of August 11th, 1957. Arrived via EMS with multiple chemical burns across his body. When he first arrived, he said that he thought maybe this was from a bug spray. Upon further investigation, the gentleman stated that his daughter had thrown some substance on him, possibly causing these burns.
Okay.
So David Backos' 911 call tells us what Konrad was saying, even then at Genesis Ascension, the first hospital he was there. Remember, he was in the room when he was talking to Lucas and to Austin. All right. Now, Lucas and Austin certainly know Konrad, and they have a ton of reasons to feel emotional about him and protective. But David doesn't, right? He's just a professional. Quite a professional, actually. I mean, I was actually quite surprised with the level and depth of his experience and how intelligently he was able to talk to you about what was happening. He has no stake in this game.
MO1, what's the location of the emergency?
And because he's a professional, he also recorded this in his notes, in the medical records. These were on Exhibit 14. It just so happens to match, again, what Lucas and Austin were saying, and what Lucas told you, and what Austin recorded in his written statement, that Megan threw hair dye and cleaning supplies on him. That's what I like to call independent third-party verification. But if there was any reason for anyone to be skeptical of what Lucas and Austin remembered and wrote down before, their testimony is corroborated 100% by someone with no stake in the game. Patient recently called that the patient's daughter had thrown something on patient. Oakland County was called about the alleged assault. Poison control called. And for poison control, pesticide bombs normally present with respiratory distress. Poison control recommended standard tox screen and standard burn protocol. Let's talk about facts and inferences applied element 2. The substance the defendant used, possessed, placed, or released was a chemical irritant, and what that means. Look, we know Lye did this to him. This was not a bug bomb. Even if you don't believe, let's set aside count 1, or element 1. Even if you don't believe Megan did this, or that she knew that it would do this, or the intent she had when it did this, it was the Lye that did this to him. And is Lye a chemical irritant? I don't really think we need to move past the bottle, right? Exhibit 9. Skull and crossbones on the front, big red label, causes severe burns. You can read more instructions. Precautions. Wear protective gloves, clothing, eye and face protection. Do not get in eyes, on skin, or on clothing. Danger. Causes severe burns and serious eye damage. It talks about do not mix with hot water. It talks about if you do get on your skin, wash immediately with cold water. This is a chemical irritant, no question. And it's only made worse when it's mixed with, other things like water. And I would say that even in this case, calling it an irritant, given what we saw happen to Konrad, is something of an understatement in the legal phrasing. But it is certainly an irritant. Facts and inferences applied element 3. That the defendant placed, possessed, used, released the chemical irritant to frighten, terrorize, intimidate, threaten, harass, injure, assault, batter, or kill Konrad Imirowicz. So listen. This is a homicide case, right? And that word homicide comes with a great deal of pressure and weight upon your determination and what you think. You think the word murder, and then the brain can come alive with ideas of what that means. So I want to talk about intent and in killing, and I want to do this by breaking down the video where Megan talks to the police. It's a little hard to hear because of the static and the technology. So I've chopped it up into little bits. We're going to go through most of the video that I showed you in smaller sections and smaller portions to keep it easier to track. And then we're going to, apply it to this element and, of course, some of the others while we do it. So this section is 2 minutes 45 seconds to 3 minutes in the video.
guess now you guys will appreciate my less static version. Good luck for your eardrums. Here we go.
Give it a second. One moment, Josh. You run this 9 times yesterday. It runs fine.
I started yelling at him crying because obviously that's like hard to take out.
Absolutely.
Stop drinking and it breaks my heart.
Absolutely, it's tough. I totally understand.
They need me, Engineer.
I started yelling at him and crying because obviously that's like a hard thing, and I'm
Absolutely.
to stop drinking and it breaks my heart.
Absolutely, it's tough. I totally understand.
And I just kind of got mad, and I'm like, all I threw at him was a bag of bread. And
So this is very, very early on in the process, right? And the first thing she goes to right away is, all I threw at him was a bag of bread. They hadn't even asked her, what she did, really. They hadn't told her, did you throw anything on him? They hadn't suggested a single thing to her. They had just asked her, tell us what happened. And she goes right to, I was throwing things at him. And she goes right to, minimizing her culpability.
that's when she like told me like, I don't think he's okay, like something's wrong with him. And I was like trying to ask her what was happening, like what was going on. But I don't know. And then my brother texted me and was like, Megan, when Kayla's done calling an ambulance, tell her to call me back. So then I told her, she called him.
So she's talking about Kayla now, and how Kayla came over and did this and called her. Now, remember what Kayla testified to, though. Kayla testified that when she called Megan and told her that he was burned, she kind of just scoffed and hung up the phone. And then she called Austin, and Austin told her to call 911. So what she told the police here is already a lie. Right? Kayla has absolutely no reason to lie about this. Let's not forget that Kayla was one of Megan's friends. She was going to the party that night. She's the person she trusted to go back and get the credit card information to pay for the hotel room. Kayla didn't take the stand and lie to you. One of them did. One of them lied to people, right? It wasn't Kayla on the stand. It was Megan to the police. She's trying to make herself look better here. And that was, by the way, 3 minutes, 30 seconds to 3 minutes, 52. We're going to move on to 3 minutes, 54 seconds to 4 minutes, 25 seconds.
Like, my mom called me and she was like, Megan, did you do this to your guy? And I was like, no, I didn't. I would never intentionally hurt my own father, and it kind of sucks that they all think I would. But I could never do that to him. I didn't. Like, there's a lot of stuff over in that area, so it could have been over there since our house is a mess.
What could have been over there?
They said chemical burn, so I don't know. But I know there's a lot of stuff over there. I don't clean it up because I shouldn't have to give you alcohol.
All right. So she's already saying I never intentionally would hurt him, right? But we already admitted to throwing things, but now it's I wouldn't intentionally hurt him. She's already protecting herself. She's already making an excuse. And I want you to remember that part where she says, there's lots of stuff over there. There could be lots of stuff over there. Because that's going to come back later.
I never clean how they're set. Maybe it's like I food like food. There's only ever food around there. I could never intentionally throw something dangerous out of my own pocket.
So now there's only ever food around there. There's no cleaning products for me to grab. That would be crazy. Why would there be cleaning products there? There's only ever food. That was 6 minutes, 13 seconds to 6 minutes, 23 seconds. So about 2 minutes later, she's already losing the thread.
Okay, is it possible that you threw some other things aside from bread?
7 minutes, 13 seconds, so 7 minutes, 20 seconds. We're now at the point where, okay, it could be possible I threw something besides the bread. It could be possible there was other stuff there.
Do you remember throwing it in the air and like caused like this white powder to run down?
Not intentional. We're not saying you intentionally tried to. We're trying to figure out what she threw.
This is random.
I don't think so. I mean, there was like liquids, but there wasn't
What kind of liquids? That's the detail we need to know.
probably like water or something. Like I don't remember.
Like a water bottle or like a cup of water.
It was in the bottle, like bottle water. Yeah.
Okay. And that's still on there?
So we went from bread, nothing but bread, to could be other stuff, it could be possible, now it's liquids. And by the way, she was specific. It was a bottle. Right? It wasn't, I don't remember what kind of liquid it was or what it was in. It was a bottle. She knows. And that was 7 minutes, 38 seconds to 8 minutes, 11 seconds for the record.
Going on. So do you want to restart and tell us what happened? Okay, so what happened?
So I was throwing things. I was just grabbing anything that was on the floor. And then I just got like, I got tired of it. And I walked away.
So she was just grabbing anything around. That was 8 minutes, 41 seconds to 8 minutes, 57 seconds.
Okay. When you were throwing stuff, right? You're unintentionally throwing stuff. Not, I understand, I totally get it.
Like, they're not adding, it's
Sure.
around.
Right, that's fine. When you threw anything, because we need to help the hospital out here. They're trying to figure out what's going on because, like I said, he's in rough shape, okay? Was there any white substance that flew out of something when you threw something at him or anything? We're trying to help your dad out here.
I think so, yeah.
Okay.
9 minutes, 37 seconds to 10 minutes, 5 seconds. It took less than 10 minutes for her to admit that she threw things that involved white powder, which we know was a lie. Had to be. And I thought it was interesting because even when she's doing this, she's still trying to protect herself because she's talking to the police and she knows she might be in trouble. That's what she said at the very, saying at the beginning. I don't want to get in trouble. Because she's saying I wasn't throwing it at him, I was just throwing it, near him. When you're throwing something at someone, unless you're playing sports, you're doing it because you want them to hurt or to feel something of the pain you're feeling because you're angry. You want them to experience what you're feeling to some degree. Throwing it near them doesn't do anything. That's not true. Right? No one throws something near someone when they're angry. Unless you're specifically trying not to hurt them for some reason. But that's not what happened here. It can't be. Not with the level of injuries we have.
You said, was he wearing a shirt? Remember? Shirt or pants? No?
I know he wasn't wearing pants because never.
Okay.
10 minutes, 11 seconds, 10 minutes, 19 seconds. I know he wasn't wearing pants because he never wears pants. That would make sense given the injuries we saw. The legs were worse, right? That's what the doctors told us, and that's what's pretty evident.
Where on the body did you see that white stuff?
It mostly went on the couch, a little like on his like lower legs, but it was mostly covered with blanket.
So 10 minutes, 20 seconds, 10 minutes, 29 seconds. It mostly went on the couch, a little on his lower legs, talking about the white stuff. How would she know that if she didn't do it? Right? She knows where it went, and she's still trying to pick herself because she says there was a blanket in the way, which is absurd. Most of it didn't go on a blanket or on a couch. It was all over it. We saw. The back of that one leg that's in that photo was completely black, from heel up to the end of the leg. So most of it didn't get anywhere on the couch. And we saw the couch. There was a little bit on the couch, right? There was a little bit on the blanket. But look at his body.
You know where that stuff was?
It looked like something for the tub or something.
Okay, alright.
Do you know what that stuff was? It looked like something for the tub or something.
Did you ever use that stuff to clean the tub? So like Drano, like Lye.
Like when I think it's for one of that. I think it's for one of them. It's like my dad uses it sometimes, like the
Do you ever use that stuff to clean the tub? I think my dad does. You know, like Drano-Lye, do you ever use that stuff? I think my dad does. I think he uses it for one of those things. I think he uses it to clog. I think she means declog, right? But she knows exactly what it is, okay? That's 10 minutes, 41 seconds, 10 minutes, 54 seconds. Do you know what this stuff does? Do you know what it's like to have that skin? Do you think it would feel good to have on your skin? This thing is easier to hear via headphones. I don't know if you're going to be able to have it in the back. So there's really two options here. Either she says something very, very quietly, or she doesn't say anything with that at all. Which would be the only time that she doesn't answer a question, basically, in this whole interview. Right? That suggests to me that she knows that it's not going to feel good. Because, of course, it doesn't. She knows this is stuff you use to declog a drain and clean a bathtub. She knows that this isn't going to be something you want to put on somebody. And even if she doesn't, you know, the bottle will tell you.
When you threw it on, was he just motionless sitting there? Yeah. He didn't try to wipe anything off, so it kind of just soaked into his skin, right? And then you took off. Is that the extent of kind of what happened?
So he was motionless. That was 11 minutes, 12 seconds to 11 minutes, 24 seconds. We know that he was drunk. We know he was very likely passed out. So she did this to a person who was unconscious, asleep, and couldn't defend themselves, and couldn't move, and couldn't take action to even clean it afterwards. Right? This is an intentional act. This isn't something she's doing even to convey the kind of rage to him, because he's not even awake enough to see it. This is something to be done for him to feel later.
Were you concerned that there was white powder on him that maybe would have ate through his skin?
I didn't know he would do that. I thought things like that just kind of sat there, nothing was happening.
I didn't know it would do that. I think things just like that sat there and nothing would happen. That can't be true. We know it's not true. Everything indicates that that's not true. But what it does indicate is that she did do it, right? She was throwing it. She knew what she was throwing. Because I didn't think that would happen. That's her saying, I did it, but trying to protect herself.
I guess my question to you is, why didn't you tell us initially you only threw threat? What were you afraid of that was going to come out?
I don't want to get in trouble for something I would never purposely put my doctor.
So this is where the police are starting to talk to her about, why did you lie to us at the beginning, right? Why did you tell us it was just Fred? Why didn't I throw anything? And she's still trying to protect herself by saying, I didn't do it purposely, which is the defense that people do when they can't accept the responsibility for their actions, right? I did something because I was angry, upset, and I meant it at the time, but now I have regrets. Regrets are fine. Regrets are good. We should have regrets when we do bad things. That doesn't change the fact that there has to be responsibility and accountability for the things you did. And it also tells us that the moment the police showed up, she knew that there was something wrong, right? She already tells in the video that, they told me it was chemical burns at the beginning, so people have called her already, right? They told her. Dad's at the hospital. He's got the chemical burns. They show up. She knows why they're there. And she is immediately defensive.
What you did today might have hurt him when we came here? Is that why you weren't telling us everything that happened?
Well, I knew because obviously, like, my brother's yelling at me, like, everyone's yelling at me because they think I'm this wrong person, and then, like, I didn't actually do that. And I just don't want to get in trouble for something I never meant to do. I didn't think it would hurt me.
This is one of the parts, I think you can see kind of the frustration of the officers here, because she's still trying to pretend that she had no idea if this was going to be a bad thing, right? But there's no question. There can't be any question. When you watch the video and break it down slow, and you think about what she's saying, you can actually take a little bit by bit. It is extremely obvious that this is an action she did, that she knew she did. She knew what she was doing. She knew what she threw. And the It's absurd to suggest that she thought that this would be just fine. And of course, it wasn't just to the police that night that she admitted what was going on.
Friday morning, I'm going to send this in a video because I don't feel like texting, but Friday morning I woke up and I went to go see my dad because I had hair appointments, so I needed him to take me. And he was drunk, and I was like upset because he's like an alcoholic and we wanted to stop and everything. So I threw a bag of bread at him because I was angry. I'm not going to throw something that's going to hurt him. And I threw a few other things, but I threw it like at the end of the couch so it like wasn't near him. And I left. And when I left, I said goodbye to him. He said goodbye. And then I needed his like card info for the hotel because I was going to a hotel for my 18th birthday. And then I had Kayla, my friend Kayla, go to my house because she lives down the street to get it from him. And she was like, Megan, your dad's not okay. And I was like, what do you mean? And she was like, there's like burns on it. And I was like, what? Like, I was so confused because I was like, why is he, like, what is happening? I was like, my instant thought was he probably, like, stood up and fell because he's prone to hurting himself when he's drunk. And I'm always the one who has to go and help him off the floor and make sure he's okay. So I was like, call my brother. I didn't know what to do, like, so I just told her to call my brother, and they called the ambulance. And it's like, apparently there were like chemical burns on him, and I'm like, I was so like, I didn't even know what was happening. And then my brother's like yelling at me saying I didn't do it. When I left, he was perfectly fine. I would never intentionally hurt my dad. Anyone that knows me knows that I'm against violence, that my dad's like my best friend. I've never hurt him. And my brother wasn't even there. And Lucas, Kobe, and Bella West over here are like, since they're all best friends, they were like talking to the police, and they were like, yeah, Megan did it. She did it. Were you there? No, you weren't there. Neither was I. Nobody knows what happened. But they all blamed me because people like you in this world don't know how to shut up. And so they all like, they blamed me. They said it was my fault. I wasn't there. I didn't. The cops came to the hotel I was at, and they were like, so your dad is severely injured. He's in the hospital, and everyone's saying you did it. You mean everyone who wasn't there? Is that so? Because what? And they were saying, like, my mom said that my dad didn't know what happened. He didn't know. Like, so how are y'all gonna arrest me for that shit? So they took me to jail. Even though I'm fucking innocent, they took me to jail. And I was there until yesterday. I got out. And then I have to live with my mom now, which is like no problem. Like, I'd rather be here and happy and be able to be the girl that I know I can be and have my future and everything. But my brother and Bella and Lucas all have my cat, so I have to go get that. The whole school fucking knows, and everyone's gonna judge me even though they don't know what fucking happened. I'm like, I have like court dates and everything, but hopefully everything turns out good, but yeah.
So that's what she sent to Blake Shelton about a week after this incident, right? Yet again, she's trying to tell the same kind of things, deflecting, saying she didn't do it intentionally. I hope you notice that not once did she ask about how her dad is. Not once did she express concern for his well-being, the man she says is her very best friend and all that. It's a lot about her needs and what she's worried about and becoming the girl that she thinks she can be. So let's talk about intent in homicides and what Megan intended to do. There are a number of homicide charges in Michigan, okay? First-degree murder requires premeditation and deliberation. It's the intent to kill and only kill, nothing else, right? The classic examples of this are like if you sit in the backseat of someone's car and wait to ambush them or poison them, something like that. That's not an intent you have to find here. Second-degree murder intended to kill, or intended great bodily harm, or knowingly created a very high risk of death or great bodily harm, knowing that death or great bodily harm would be a likely result of her actions. That's sometimes called depraved heart murder. Okay? This is someone whose actions are so reckless that they have to be criminal, and it's just absurd. One of the classic examples of this one is if someone's playing Russian roulette and slips a bullet in the gun, right, with their friends. And you don't know who does it. Voluntary homicide. It's the same elements of second degree for intent, but it has to be triggered by some intense event. The classic for this one is when you stumble upon your spouse and they're cheating on you. And you snap and you kill one or two of them. Right? That's voluntary homicide. Your charge is not that. It's none of those. You don't have to find an actual intent to kill ahead of time. You don't have to find that she did this with the desire to kill him. Just that she did it with the intent to frighten, terrorize, intimidate, threaten, harass, injure, assault, batter, or kill. We're not playing video. Actually, I just want it to be, 1 second, Judge, I just want it to be in one mode now. The intent on our charge. Of all those options, right, to frighten, terrorize, intimidate, threaten, harass, injure. These are all things that have pretty standard definitions. Any of them can work. You know, intimidate, this could be done to intimidate. After he wakes up, right, he was behaving in a manner that she didn't like, that was pain, that caused her a lot of anguish. And so now it's you're going to do change. Look what I can do. Look what I will do. Look what I have done. It's time to change. To threaten. Look what will happen if you don't. Right? To injure. That's certainly something that was done here. Or to assault, batter. Right? That's an attack. To do something when you're trying to cause someone harm, and to hurt them, but maybe not kill them. You don't have to find intent to kill. I think you can. I think there's enough evidence to do that. I think when you look at the burn patterns and the injuries, which I'll probably go over later, you might be able to find intent to kill here. But you don't have to. And the thing is, you all don't have to agree on which intent you find. One of you can think it was intent to kill. One of you can think it was to intimidate. One of you can think it was to frighten, because I bet when you wake up and you have burns like that over, it's scary as hell. Certainly Austin said it was scary, and that his dad was scared when they were at the hospital. You don't have to agree on which one.
Okay, so you're in my shoes, right? How old are you? You just turned 18. If you were to throw, and to be honest, truth, if you were to throw Drano, household acidic cleaners on someone's body, what would you think that would do? I mean, we're both smart individuals. It's probably pretty.
I didn't think like a powder alone would do that.
Well, you said you threw water too, right?
Yeah, the water and the Drano.
Okay. So, at this point, I'm going to have you turn around. You are under arrest, okay? All right, so turn around, place your hands behind your back, okay? We'll try not to make it.
She knew what she was doing. And she knew what the intent was. And it was so preposterous that the trooper here, after not even 15 minutes, was already, rubbing his head like, are you serious with this stuff? Can you really be still trying to say that you didn't know that this would happen? Or that something would happen? This gets us to the last element. That the possession, placement, or use or release of the chemical irritant resulted in the death of Konrad Imirowicz. I don't really think there can be a dispute here. I don't really think there is a dispute here, frankly. But let's just go over it again. Dr. Varane perhaps the expert of all experts in homicides and in forensic pathology. 20,000 some autopsies, right? 31 years. Cause of death, chemical burns with complications. Manner of death, homicide. 64-year-old white male Konrad Imirowicz died of chemical burns with complications. He sustained these burns when caustic chemical was thrown on him. He survived longer than 5 months of medical treatment for these burns. There were no other physical injuries. The manner of death is homicide. The only other alternative that's been posited in any of the evidence in this case is this idea of the bug bomb, right? Now, everybody up there told you that this couldn't be a bug bomb, and certainly that there would be some injuries to the lungs. There were no injuries to the lungs. First, these are the Hurley medical records, page 45. There is no associated inhalation injury. It's not there. And then when it came to Dr. Virani, there was the scarring on the lungs, which he said could only be a result of repeated infections, which is what happened here. Konrad spent 5 months at the hospital. 5 months in which they were trying to save his life. It was 153 days he was there, and after he went off life support and went home, it took him only 3 days to die. He got 3 days after 5 months of horror. The elements in total. The defendant placed, used, or released a substance. No question. She admits it. The substance that the defendant possessed, placed, used, or released was a chemical irritant. This is perhaps the least arguable element of them all. The defendant possessed, placed, used, or released the chemical irritant to frighten, terrorize, intimidate, threaten, harass, injure, assault, batter, or kill Konrad Imirowicz. There is no other reason you pour Drano on someone's body unless you are trying to do one of those things. And if you do it on accident, you clean it off right away because you know what it is. And that's what's crazy about this most of all. She put this on him and left. Right? She put this on him and left and had no reason to believe anyone was coming back. The only reason Kayla went back is because she called her and needed the credit card. But there was no reason that this passed out man unconscious was going to have anyone come and help him. So she just left him there like that. She didn't clean it. The only option that this wasn't going to get very bad was if he woke up from his drunken stupor. And this is a girl who's doing this because he's drunk all the time. She knew what this was going to do. She left him to burn. And that the possession, placement, use, or release of the chemical irritant resulted in the death of Konrad Imirowicz. I want you to think about all the evidence in this case and all the burns, and whether or not there's actually any dispute to any of these elements, really, from the defense that was put on. Listen, the burden is mine, okay? I think we've met it, but since they did call witnesses and they did cross-examine and ask questions, I get to talk about what they said and what it implies, and what the defense is. Did anything that they put on, or any questions they asked, or the answers that came with those questions is the evidence you consider, not the questions themselves, did anything call into question what happened? No. Nothing actually called into question if Megan was there, if she's the one who did it, what was done, the damage that was caused, the knowledge or intent. Nothing. There's not a factual dispute. And so what happened is over. And now it's did what happened break the law, and there can't be a dispute there either. Ladies and gentlemen, I get another chance to talk to you in a little bit after Mr. Miller goes. And so we'll see what is said, and I'll respond to that, and maybe talk a little bit more if I think it's necessary. But I think we met our burden here. I think this is one of the worst cases I've seen. I think the injuries speak for themselves, and I don't think there can be a question about guilt. She wanted to hurt him because she was angry, upset, and she did so in a truly terrible way, and I think she's guilty. And I think the evidence shows she's guilty, and so I'm going to ask you to give her the consequences that I talked about in the beginning, the consequences of her choice to hurt him, and find her guilty on count one. Thank you.
Jeez. Yeah.
Okay, it's time for the defense's closing arguments. Let's see what they say.
I assume you're ready for me. All right, thank you. Ladies and gentlemen of the jury, this is my last opportunity to speak with you. Mr. DeSantos gets one more shot. I want to thank you for sitting here. This is not one of the most pleasant cases in the world, but I want you to take a look at everything first and listen. I want to play the video of Konrad Imirowicz.
Right now?
Yep, I'm ready.
Okay.
This is what the victim had to say, and it's rare you get a chance to see what the victim has to say.
Something set her on. She wanted to go to the beer.
Here, I'm just going to start it from the beginning.
That was close, but
something set her on. She wanted to go to the beer. I need a new place. I couldn't get her in for whatever reason. So we're going to go to a hotel. Then she wanted her hair colored. She's got really dark hair. Want to be black like your mask. And it's very hard to color.
Okay, but you got a pacemaker, right?
No.
No?
No.
Alright.
I have nothing.
Nothing in you at all?
No.
Do you mind if we go in your house?
Go ahead.
Okay.
Door's open.
That's fine.
And so I don't know. Last night I noticed you threw a bunch of stuff at me, got mad.
What is like stuff meaning?
There's she rearranged her bedroom, so there was a mattress on the wall. She heaved that and went crazy on that stuff. I've asked her to take out the garbage several times, and that hasn't been working. But
is this kind of I'm trying to gauge this. Is this a normal behavior that she would throw stuff on you to burn you?
No. She usually gets an argument. Okay. I get mad at her, she gets mad at me. We badmouth each other. It's not normal. Okay. Right? But this is very, very. So last night I had half a Smirnoff, put the bottle down, put the cork back on.
The Smirnoff?
No, the little one.
Oh, the airplane size?
The Smirnoff, what do you call it? Ice.
Oh, a beer, like the beer thing.
Beer thing.
Yeah, like the seltzer.
The little seltzer, right? The lemonade. So I have to watch a movie, shut off my phone, call it a night, pretty early. And this morning, I got up, finished my Smirnoff, watched the rest of the movie, and back to back. And they said, I got all kinds of people in the house with still,
Were you sleeping when this happened, or were you unconscious?
No, sleeping. I wasn't unconscious. We didn't have anything to drink. I don't even have the Smirnoff. Give me a break. I was thinking about getting her some breakfast and stuff, or making some. I was going to get her a breakfast because I was got a 2 for $5 thing going. Keeps. So I was going to do that. No, you done. Or am I just moving too much? Okay. All right.
I won't bother you that much. All I need, if you don't remember, you don't remember. All I just want to know if we can go into your house to investigate what happened.
Go ahead. Okay. The door is open, right, Austin? It's unlocked.
The door is open. Yes, I have us.
There's a bunch of cats.
Let me talk to him and then we'll talk out there.
All the cats can go out except for a little gray one. I mean, she's tiny.
Right.
Padawan, she's not old enough to go outside yet.
Okay.
But they're.
You mind if I see your hand? If you just want to flip it.
Pull this cover off. I can't. The legs.
Carefully show the legs. Are you wrapped up in this?
Yeah, good.
I didn't know if you were acting like a bunch or what. Can you see that good enough, or do you need a little more? Okay. It's like this.
Get this side. Yeah. Get to the food.
Is he okay to lift that up like that?
You feel it? All right.
Do you have it on your back? You don't have to get up, but I'm just asking. Okay.
It's part of him.
Okay.
I don't know. I didn't see my show him if you want the full back.
It's this okay.
Can I show him the pictures that I took?
Yes, you can.
Perfect. Okay, I will. I appreciate it. You get better, and I'll keep in contact with your family. Okay.
That's awesome.
Yep. All right. All right. Bill.
That's all I'm going to show you. Hit the lights back, okay? Rarely get a chance to see the victim make a statement. His statement is that he was asleep. He doesn't know who did this. He doesn't know what happened. He was intoxicated. Well, actually, he didn't say that, did he? He had one spirit off ice, but they told the trooper that he was a .3, which is close to 4 times the legal limit to drive. Now, if we go over the witnesses, Kayla said, I got communication from Megan. 10:30 in the morning. That's when supposedly all this happened. But based upon her statements, if I remember correctly, she didn't leave till 2:30. Now, she also said in her little interview she had talked to her dad. If you remember him, he remembers the incident, and he remembers her throwing things at him, an argument. He got up afterwards. He watched a movie, had the last of his Smirnoff Ice. That's what he said. Now, it's unfortunate that the troopers didn't get any fingerprints, didn't take a look and see what liquids were there, didn't do any investigation into the house. Basically, the troopers are there. They know he's burned. They know somehow this got on him. I mean, the officer in the tape says, yeah, we're looking into this to investigate. Is this a self-inflicted accident, or did you pour it on here? Now, let's think about this. She's 18 years old. This is her birthday party. This is 12:30 at night. She's already aware that her father has chemical burns because her brothers called her and contacted her. She's already aware of what's going on. They go there. She's cornered back in a vehicle with her back to the vehicle with 3 officers on this side. She's 18 years old. She's at a party. Did they look at her and say, well, how you doing? Is it okay? They cornered her and put her in the car, put her there so they could get what they wanted, a confession, so they wouldn't have to do any more investigation. She's 18 at a party. And did they check for alcohol? Did they look at her eyes? Did they do anything? No. They said they went there to investigate. They asked her. She said, this is what happened. They weren't happy with that. They kept going. They pushed this. Their job's to close this case out. Their job's to get a confession. And that's what he got. He wasn't happy till he got what he wanted. He went there to arrest her. That's what we've got. Now, Mr. DeSanto said that in those medical records, you'll find statements made by Mr. Imirowicz blaming his daughter. No, you won't. Nowhere in those medical records does Mr. Imirowicz blame his daughter. Everyone assumed it's her. She lived there. They assumed it was her. They did no investigation. They did nothing. Close their case out. They're done. Just look it on the floor. They didn't find out what kind of liquid it was. Although his ex-wife testified she went in there and there was a bag of feces at the thing, at the couch. There was liquid on the floor. Frankly, it's probably his urine from sitting there. The couch was in bad shape. Nobody tested it. There's fleas. The bathroom downstairs in bad shape. This is a house that is a nightmare. This is a house I hope none of you ever have to go into. This is a bad situation. There's trash bags. They have to move the trash bags to get up the stairs, to get him down. She indicated she threw some stuff at him. Yes, she did. This is 10 o'clock. She indicated to Kayla again, can you come get me so I can go to the party? And then she got another text that said, oh, I got someone else to pick me up. She was gone. Now, it's true. She needed to get the tab or the credit card information. It's true. She called Kayla. Can you go over to the house? You live there. Kayla went over. Kayla said she's walking up the stairs and Mr. Imirowicz said hi. And then she got there and she saw the situation. It was a bad situation. This is 3:30, 3:45. If Mr. Imirowicz was chatting, he still was drunk. Because at that point in time, he didn't have any more to drink. They came and got him. It's 3:45. At 9 o'clock, we know his blood alcohol level was a 0.3. Very high. He didn't have anything to drink, we know, from 3:30, 3:45 to 9 o'clock. Now, if they're saying that this occurred at 10:30 in the morning, he would have been unconscious all that time. How much would have he had to drink? Where he wouldn't have been alive. It's not possible. But remember, he was doing something. Something about a bug bomb. There's fleas in the house. Again, not a good situation. What did he do? He got up. He watched his movie. He had his Zima. Or not Zima, excuse me. He had his ice, supposedly. Even the trooper said, look, he had more to drink than that. That's not possible. So, who put it there and what happened? The house is an utter disaster. You know that. It smells bad. You know that. There's stuff all over the place. They didn't look for anything. They didn't do anything. They had their answer. Okay. And I ask you to take a look, if you want, at the medical records. You won't find anywhere in there where he says she did this. It's not there. The nurse didn't testify that he said it. It's based on everyone else and what he thought. Something occurred. Clearly something occurred. Someone might be to blame. Who do we got? Well, Megan lives there. We know she's around at some point. Blame her. It's possible. Troopers went out with one goal. Get her to confess. Their case is over. What happened? Well, if you deport that stuff on at 10 o'clock in the morning, I doubt he would have been alive. But we don't know because we didn't test anything. We don't know how long it was on his skin. We don't know where it came from. And by the way, they're saying it was spread over him. Nobody said anything about her hands being in bad shape. The hands were in bad shape were Mr. Imirowicz's. The only way those hands get in bad shape if he's spreading it around himself. If he's rubbing it in or moving it around or doing something with it. You look at the jar, there's still stuff in here. Still some of that chemical in there. All right? It's still there. Whoever had to throw it clearly had to get something on their hands. Or did he dump it on himself? His hands are in bad shape. Hers aren't. Nobody said anything about it. This is a man who is, well, I understand he passed away and this is involved in. This is a man who, when he was married in 2007, was on medication for high blood pressure. He clearly is an alcoholic. He had liver problems, which he clearly had kidney problems. He had some bladder problems. His son had moved out. He's got some issues going on. He's not in good health. Shows up to his son's graduation ceremony, half his head shaved, dirty, clearly intoxicated. He's an alcoholic. He doesn't remember what happened. He remembers something about doing something with the bug bomb. Was it the bug bomb? Was it this? What happened? You got to look at it and try and figure it out. I'm asking you to take your time, think about it, take a look at the exhibits. Remember what was said. Think about it when you were 18. What would you do if you're backed into a corner? You got a car behind you, 3 officers around you. It's night. You know your dad's been hurt. I'm not taking the first answer. They're not taking the second. They're going to keep going. You were at a party. What kind of condition are you in? What's going on? You're afraid. Your brother's already called you and said, you did this, Megan. This is a difficult situation. Nobody's saying she intended to do anything. Well, Mr. DeSanto's actually saying, yeah, she intended to kill him. I don't think so. You get to reconstruct. You are the trier of fact. You're the ones who will make a determination. All right? Now, when you go back to the jury room, you're going to be able to take a look at all the evidence. You're going to take your time. A couple of you are going to be dismissed, and they'll sit down, you'll figure a foreman out, and you've got to look at the whole situation. You saw Megan's tape that she made. Is that the truth? Is it a lie? She's under no pressure. She's trying to talk to a friend. That she's in front of 3 officers. You can see lights behind her, dark situation. They never checked. They never asked her. They never advised her she had a choice. They never did anything other than get what they wanted and what they wanted her to say. They knew what they wanted. They suggested, but what about the white powder? He said she threw a bottle with water. And this house, I wouldn't want to be in it either. They didn't go in, they didn't do an investigation. Never found the top. Never found where it was at. Never found what it was used for. Never found out how old it was. Never looked and see where it was bought at. Never looked and see how much was in it, how much was left. Never questioned anybody about it. Never did anything. No prints, nothing. It's Megan did this, let's convict her, let's get it over with. Well, that's not necessarily how it works. Now, ladies and gentlemen, This is a tough case. There are some really nasty pictures here. I'm going to ask that you look past them. There's injuries, no question. There's damage, no question. Look past that. Look at the whole situation. Try and figure it out. They're all saying this happened at 10 o'clock. Mr. Imirowicz didn't say that. All right? He said, yeah, he remembers us throwing stuff and everything. And then we were done. We had a little spat. He then went and sat on the couch, had his Zima, or I keep seeing Zima, on ice. It probably tastes as bad either way. I don't know. All right. But you got to take a look at the whole situation. Remember what he said. And yes, they came down and they arrested Megan. She made statements. She's backed into the corner doing what she's got to do. Officers are doing what they have to do. She knows there's chemical burns because her brother's already yelled at her. They're looking for that information. Nobody told us what was on the skin other than the chemical. Nobody said there was any water on it. Nobody proved anything else on the skin. Nobody indicated how long it would take for these burns to last. Nobody knew how drunk he was, what he was drinking prior to. We know he was at the hospital. So that was a 0.3, and you saw him talk. That's a 0.3, and he's doing pretty good. When you deliberate, please take a look at all the evidence. Take a look at everything else. Figure it out. I mean, clearly, things are thrown. Clearly, there's a domestic situation. Father-daughter, they're living in the same house. There's an argument. They argue a bit. I remember her throwing things. He doesn't say anything about chemicals. He got up. He had his he put off a bug bomb. That's a little odd. What else did he do to try and clean up? Why else was the lie around? Everything was up there. We don't know. They never checked into anything else. There's no other statements by Mr. Imirowicz. There's nothing else you can find. It's a difficult situation, but beyond a reasonable doubt, is she the one that did this? I don't think you'll find that. I think you'll find it for the domestic assault, there's no question. And clearly it happened in Oakland County. Clearly it happened on or about that date. No question. I mean, that shouldn't take much for you to figure out. I'll stipulate to it. Doesn't matter. I agree. But what Mr. DeSantos and I say are not facts. They are not what count. What the documents, what the evidence, and what you make a determination of is what the facts will be. That is your job. I'm asking you to take your time, think about it, and do your best. And don't change your mind just because you want to get out of here. You have to figure out what you want, what you believe justice is, and make that determination. You already know the situation. You know the house is terrible. You know it's a divorce situation. You know the family's got problems. Mr. Imrowicz's son is an angry young man. I might be too if my father had gone through this. I don't know. It's up to you to determine. Ladies and gentlemen, thank you for your time, your patience, and I wish you luck. Thank you.
Thank you.
Oh my word. We're done. Rebuttal time. getting the video ready again.
I want to take a couple things in turn. And the first thing I want to talk about is the idea that no one, or Konrad, ever said that Megan threw chemicals on him, except he did. He said it to Lucas and Austin, and it was heard by the nurse, David Bodges. And that's what he said. David Bodges said, I was in the room and I heard him say that. Konrad say that. So it's difficult to remember testimony from a couple days ago. I understand that. It's hard. But that's what he said. I was in the room and I heard Konrad say that. This is not secondhand information that kicked this whole thing off. And it was David that reported the assault and started this. It wasn't Austin or Lucas. It was the nurse with no stake. Okay? One of the other big things that counsel focused on was the interview and the police and her just, taking what's going on. Apparently, if a police officer goes up and asks someone a question, they have to take the first stand for that scale. And they're not allowed, apparently, to say, okay, well, that's what you say, but what about this other stuff that was there? Because that's what's happening, right? It's not a suggestion that there was white powder. They're saying, okay, but there was white powder there. What's your explanation for that? That's not telling her what she's supposed to say. What Megan did when she was talking to the officers was took an explanation from them that was less serious than what she did. And I'm going to explain why. So I talked about the elements and how all that, what came before, was absolutely enough to convict. Okay, Megan's version of this, the one she was the most honest, right, was near the end when she's actually admitting that she threw stuff at him. But it's actually quite worse. Excuse me. All right. So I want you to see. Let's take a look at Exhibit 1 here and Exhibit 2. Let's take a look at the scene.
Yes, let's look at the scene. Only now?
This is the couch. Left side. All right. If you take a look up here, you can see some white powder substance. If you take a look over here, you can see a pack of Smirnoff Ice, presumably a Smirnoff Ice bottle. The bottle cap for it's right there. You can see a table or a chair here, all right? This is all completely blocked. These are all like food products and clothes. Okay. The other side of the couch. There's another couch, right? Love seat, something like that, another piece of furniture. Empty fish tank, and a bunch of stuff. Clothes, blankets, food products, right? No chemicals anywhere. So if we recall, Megan said that there was chemicals, and then she said there wasn't, and so on. There was food, but maybe there was chemicals. All right. But let's think about this logically, and the burns that he had on him. Let's first talk about this idea that this could have possibly been self-inflicted. There's nothing to suggest that Konrad was depressed or suicidal at all, so that's just pure speculation, number one. Two, I would speculate, since we're clearly speculating, that in the history of the human race, no one has killed themselves in this fashion. Right? This is not how someone does that. I can't think of a worse way to go. That's absurd. So let's put that out there. The second thing is the nature of the injuries and how they are distributed on him. Okay? They're from literally his head to his toes. The whole way. So let's remember, you had injuries on his feet, the whole way up his legs, on the back of his legs mostly, and a little bit on the front. Up on his arm, the back of his arm, on his fingers, and on his hands. And so to illustrate this, I am sorry, but I am going to show some of these pictures again. So,
What are we gonna see now? Did you see the water bottle on the couch? I was trying to show you.
Back side of the leg, front of the leg.
Okay, don't show us. Don't show
Arm
us.
and elbow. The fingers and the hands. Right? And it's mostly here on the thumb, okay? And then here on the fingertips. And then you have it here on the left shoulder, some on his left neck, then on his back. And look up here. Where the burns are here, on his left shoulder, thick, still thick, and kind of trailing off. Now, and then up here on the top of his head. Now, let's remember what Dr. Virani said. Okay? He said that he was almost certainly, because of the pattern of the burns, laying face down or partially on his right side. And that's exactly what's shown here. And it's the whole way along his body. And he was motionless. Right? We know this. He was passed out, he was motionless when this happened. And there's no space at either end of the couch for her to stand. If she's upset and just throwing powder willy-nilly, right, which would get the powder on her hands, as counsel was saying, maybe, might. How, if you're picking up and throwing stuff, is she throwing this straight onto the couch horizontal, straight on the couch, and getting that distribution of injuries? Right? She can't access either end to throw it possibly along his body and get there. That's not happening. She's throwing it straight on, except that's not possible. So let's talk also about some of these. You recall the spackling, right? Dr. Seawald mentioned how some of these injuries, there's thicker parts, there are deeper burns, and a little bit of speckling. This one in particular shows it. These injuries here that I'm looking at, the little smaller bits. That looks like something that would come from the dry powder, right? The powder from here. That could happen when you throw it this way. But these other injuries are much thicker, much deeper, much more consistent. This is not the same as these specklings. This is not just purely dry powder. This is powder that's gotten wet. And so I want you to look at this bottle and look at the powder that was still inside of it and how dry it is. And think about the powder that was on the back of the couch. And then I want you to look at this photo with the lye on the bottle. And I want you to look at the lye here on the couch. This is clumped, right? This isn't the loose powder that you're seeing here. That stuff's wet. Look at how clumped and thick it was. Look at the difference of the injuries and the spackling. If you had, it was all completely dry and she was just throwing it straight on angry willy-nilly like she says she was, like her claim that she accepts from the officers, right? You don't get this injury. You don't get the kind of thick burns, deep burns we have. If it was thicker and a paste, clumped up, maybe. Or if you mix it with water first. Because the water cools underneath the body when it's poured on. Think about where the injuries are worst, when he's face down. She's laying face down, and she pours it on him, starting at the back of the legs. He's laying on the couch. You get the back of the leg that looks like that. You get some of those thick burns in the front, where he was face down, and the water cooled on the couch underneath him. You get instances where if she's going up from bottom to front, you're going to get to the top, probably start running out, right? And if he's laying on his right side, mostly face down, as Dr. Virani indicated, you're going to get that kind of drain trail over his shoulder. So you're hitting the left shoulder, and it goes down and comes underneath the shoulder where it would roll if it was already mixed in with liquid, if it was a solution. And there was liquid on the floor. There was a pool of liquid on the floor, according to both Lucas and the defendant's mother, and that couch is soaking wet. You can see it. Right? You can see the dampness there. And you can really see the dampness here in People's Exhibit 2. I wish this would stop doing this to me. Now, Julie Conrad would have you believe that this is a line from the couch being well sat in. Right? That's liquid. And then we think about the bottle cap. Where was the bottle cap? Look at all the other stuff around. There's no cleaning anything. It's just food. She didn't grab this out of some misguided piece of anger. She wasn't just grabbing things and randomly throwing things. First off, there's nothing else behind the couch. Surely if she's throwing all kinds of stuff in the bread, it would be shown, right? It would be here. We don't know where the lid is. I suggest that she got the bottle from somewhere else. And the lid's there. Right? That's why there's no lid around, is because she got the bottle, put water with it, and poured it on. Because it's the only way you get burns this thick. And it's the only way you can get the couch this wet and the water on the floor. Now, I want to talk a little bit about some of the witnesses they called. Listen. Konrad was drunk. There's no question about this, okay? He was. The idea, though, that if, he's telling you to extrapolate backwards in a certain amount of time when we don't have exact times because there wasn't enough people there. And he's asking you to take the exact word of the man who was apparently so drunk that if he had been at this point, he would have been literally dead, to have a perfect recall of exactly which moments and which times, and then he would probably be dead. Except there's no evidence on the record. And you have to only consider the evidence on the record as to the rate of absorption of alcohol for each individual person and what he would have been. Also, when he says it's a 0.3, what the hospital had was a 0.355 milligrams per deciliter, which we established was not the same measure as is used when we're talking about drunk driving. It's not the same measure. Is he drunk? Yes. No dispute. But to say that he surely would have been dead, so this is all wrong, is not the case. All right? The whole thing with the poop on the floor from Julie Conrad. First off, no one else said that. And there had been other people there. Kayla had been there. Austin had been there. Lucas had been there. Kevin Mason, the EMS, the paramedic of 15 years, and the fire chief had been there. No one else is talking about any poop on the floor. The person who did say that was the defendant's ex-wife and mother, the victim's ex-wife and the mother of the defendant charged with killing the victim. She said that while making jokes about, it looked like a tiger or there wasn't a tiger in the house, so it couldn't have been a cat, because this is apparently something we joke about. Okay? I was stunned by that. I thought it was inappropriate. But this is not a person who is credible. All right? So I don't know why we'd be taking her word for anything, but I don't think there was anything on the ground like that. But there was the water. Okay? And so then we're back to what I thought was perhaps the most interesting thing that defense counsel said, which is for you to decide what you believe justice is. And that's the whole thing about this, and everything that they've said in the entire presentation they've made, is that Konrad was a drunk and the house was messy. And what do you think justice is in this situation? The only way I can interpret that question in this instance is that somehow this was justified, right? They're trying to go back to 2007 for our victim's behavior and his health status. For the record, if he was on this stuff since 2007, he wasn't dead at 2021. I doubt it suddenly killed him in this moment in time on its own, right? But what is justified? Families are hard. They're complicated. Lots of bad things happen to a lot of families far too often, and it can be very difficult. And there's no question that this family was broken and is more broken now and will never recover. They're never going to be the same. But to suggest that because someone may have been a drunk or may have been a hoarder, that this might be justified is ridiculous. And it's offensive. There's no conception of this being justified, especially not in this country. And let's also remember that if this was such a bad situation for her to be in, that this could be justified, and what justice is wouldn't be a conviction here to what obviously happened and what had to happen, she could have gone to her mother's at any time. Right? She didn't have to stay there. She chose to live with Konrad in these conditions, in this supposed squalor that was so terrible and offensive to everyone. She chose to live there instead of living with Julie. And she could have left. What justice is, there is justice to be had in this case. And it is a conviction, as charged on count 1. Because that's what happened. And it broke the law. And we don't take the law into our own hands, and we don't decide justice based on the character of a person who was killed. This isn't about him. This is about what she did to him. She's guilty. That's justice. And I ask you to find it so. Thank you.
Ladies and gentlemen of the jury, you have now heard the closing arguments, and this case is finished. I will now instruct you on the law. That is, that I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching a conclusion that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each witness said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given some instructions about the law. You must take all of my instructions together as the law that you are to follow. You should not pay attention to some instruction and ignore others. To sum it up, it is your job to decide what the facts of the case are and to apply the law as I give it to you. In that way, to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This means this presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after careful and considered examination of the facts and circumstances of this case. Every defendant has an absolute right not to testify. When you decide the case, you must not consider the fact that she did not testify. It must not affect your verdict in any way. When you discuss a case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else that I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments and any commentary, they are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things that the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your questions to the witnesses, and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, summary of the evidence, and instruction are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express an opinion about the case. If you believe that I have an opinion about how you should decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide the case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge that you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything that a witness said. You are free to believe all, none, or part of any witness's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice that you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time that you need to test what might be an automatic or instinctive judgments and reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may be helpful to think about these questions. Was a witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to make an honest effort to tell the truth, or did the witness seem to evade the question or argue to the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, or suggestions, or other influences that affect how the witness testified? In general, does a witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony that you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part that you think is true and ignore the rest. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about October 1st, 2021 within Oakland County. The prosecutor has introduced a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made, and about all the other evidence in the case. You may consider the statement in deciding the facts of this case and in deciding if you believe the defendant's testimony. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and you see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat, covered in small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or in combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence you believe. You have heard evidence that before the trial, a witness made a statement that may be inconsistent with the statement here in court. You may consider the inconsistent statement made before the trial only to help you decide how you believe the witness's testimony when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of truth of whatever the witness said in the earlier statement when determining the facts of this case. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant has a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that she meant to do so. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts or circumstances and evidence. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and the evidence that you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer talked to one of the witnesses. There is nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about a case and what the witness's testimony will be. You have heard testimony from a witness, Dr. Kenu Varani, who has given you his opinion in the expert field of forensic pathology. Experts are allowed to give opinions in court about matters that they are experts on. However, you do not have to believe the expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe the expert's opinion, think carefully about the reasons and the facts that he gave for his opinion and whether those facts are true. You should also think about the expert's qualification and whether his opinion makes sense when you think about all the other evidence in the case. You have heard testimony from a witness who is a police officer. That testimony is to be judged by the same standards that you evaluate the testimony of any other witness. The defendant is charged with committing an unlawful act with a chemical irritant or device for an unlawful purpose resulting in death. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant placed, used, or released a substance. Second, that the substance that the defendant possessed, placed, used, or released was a chemical irritant. A chemical irritant means a solid, liquid, or gas that, through its chemical or physical properties alone or in combination with one or more other substances, can be used to produce an irritant effect in humans, animals, or plants. And third, the defendant possessed, placed, used, or released a chemical irritant to frighten, terrorize, intimidate, threaten, harass, injure, assault, batter, or kill Konrad Imirowicz. Fourth, that the possession, placement, use, or release of the chemical irritant resulted in the death of Konrad Imirowicz. You may also consider the alternative offense of domestic violence. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant assaulted and battered Konrad Imirowicz. A battery is a forceful, violent, or offensive touching of a person or something closely connected with her. The touching must have been intended by the defendant, that is not accidental, and it must have been against Konrad Imirowicz's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit a battery or to make Konrad Imirowicz reasonably fear an immediate battery. An assault cannot happen by accident. At the time of an assault, the defendant must have the ability to commit a battery or must have appeared to have the ability or must have thought that she had the ability. Second, that at the time Konrad Imirowicz was a resident or former resident of the same household as the defendant. When you go to the jury room, you will be provided with a written copy of the final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a businesslike manner and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agree on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you are wrong. Try your best to work out differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations, or questions about instructions that arise during deliberations, you may submit them in a writing in a sealed envelope to the court clerk. The possible penalty should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix a penalty within the limits provided by law. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to the court clerk. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in this case. As you discuss a case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and the full instructions. If you want to look at any of the referenced documents or exhibits that have been admitted, just ask for them. When you go to the jury room, you will be given a copy of the written instructions that you have heard. As you discuss the case, you should think about all my instructions together as a law that you are to follow. The defendant is charged with one wrongful act in an alternative count that she is guilty of chemical irritants, unlawful use, or domestic assault, but not both. You should consider these alternates separately in light of all the evidence. You may find the defendant not guilty of chemical irritants, unlawful use, or guilty of domestic assault. I have prepared a verdict form of the possible verdicts. You will get one copy of the verdict form, but each of you will have a copy of the jury instructions. We will now dismiss 2 jurors who will not participate in the deliberations. Juror in seat 1. And juror in seat 6. You will not participate in the deliberations. I will be speaking with you in the hallway once everyone else has returned to the jury room. You may both go to the jury room and collect your personal items that you have left in there, okay? Okay, thank you. Anything with regard to the instructions?
Not in regard to the instructions, Judge. I was just going to ask for the alternate jurors who are being dismissed, they should be reminded not to watch any of the coverage in the event they are needed to come back.
Thank you. Yes. Both of the jurors who are not going to be deliberating at this time, you are still considered alternate jurors. Your service may be needed in the future, so you are not to have any discussions still with regard to this case until the matter has fully concluded. Okay. Anything further and with regard to the jury instructions?
I'm satisfied, Judge.
I'm satisfied as well.
Okay. All rise for the jury. This is the verdict form.
Okay, so it didn't sound like a murder charge to me, even though those articles we read earlier said in March they upgraded it to a murder charge, right? Did you hear that? So, from what we had earlier, charged with unlawful possession or use of harmful devices, imitation, irritants, causing death, a felony, and misdemeanor DV for the October 1st, 2021 assault of her father, Konrad Imirowicz. Okay, so that's what we have there, right? And put the old one back on. We will, sorry for black. I'm like deep breaths. I'm just looking at her like, damn.
Okay. Thank you. I will let you know if there are any notes or anything from the jurors with regard to the exhibits. You should have those prepared and ready to go. Is it a flash drive?
For the videos and such, Judge, I have the pictures for the other things.
Okay, make sure that we can play the flash drive, please. Okay, thank you, everyone.
This mom, I think she wants to charge that guy. Damn, okay. We're gonna look at some pictures in a moment of the house. Thank you. I'll have a look who sent it to me. Thank you. There's a few people who sent it to me. Thank you so much. Blue Bear Art says, so the judge didn't ask the standard question about dismissing the case if the prosecution has not proved the case. Well, this trial is a little bit disjointed, hey? A little bit hectic. Sure. Thank you for watching it with me. I find it very interesting. Yes, we were very spoiled during the Letitia Stout trial with the professionalism all round and just the evidence, right? This is like, what is going on here? So I've made some notes that I'm going to share with you in a moment. Maurice Australia says, gee, thank you for always keeping us posted and covering these cases with us. Urgent watermelon needed after the SPAD trial. Definitely. Thank you so much. I really appreciate it. That will be added to my watermelon fund. I'm going to have so many watermelons. I wanted to show you quickly these pictures here. And I'll show you some, I'll talk about some notes I made over here. Well, let's see. The jury's not deliberating. Don't know how long they'll be. In my opinion, I think they could be a while, right? Okay. So let's look at this quickly. Naughty. Showing my other email addresses. Don't worry if you saw it. I never use those. Okay, don't try email me there. Okay, so here's some pictures of the house. Let me just see if I could see who sent it. Thank you to Diana. Really appreciate it. Maybe I should make it a little bigger for you, huh? So they say last sold. Sold on April 11th, 2023. Somebody bought this house now. Okay, go there. So this is the house where it happened on October 1st, 2021. Okay. Dr. Patrice Berry, welcome. You say, this is really sad. My guess is the jury will take about a day. We'll see. I'm thinking so too. I'm thinking they could take a day or two, you know. Today's Thursday, so today and tomorrow, the rest of today and tomorrow. Maybe by tomorrow night. I mean, I wouldn't blame them if they took the weekend as well to think about it. But yes. Okay. Thank you so much. So here's the house. Okay, if we go to the next picture, it doesn't matter. It's not really, you know what I mean? The hoarding. I don't know what to say about it. It's like, ooh, I've watched that show. Oh man, that's quite hectic. So we'll talk about that, but I just wanted to show you this in case you haven't seen it yet. So, okay, they're showing the ground. Very interesting, yes. Yeah, okay. Michigan, yes. Janet says, that house sold for $171K? That's a steal. It's a freaking steal, everyone. Somebody bought that and they're going to be cleaning like all of us want to do right now, right? We want to start cleaning our house. So, yeah, there is a picture of it. Yeah, Linda said nobody mentioned the poop except the ex-wife. True that, true that. But man, when that prosecution said that and she's not credible and she's not this, like she looked like she was a rhino ready to charge. Remember, I'm from South Africa, okay? I've seen rhinos and elephant charging. She looked like she was ready to charge. Like, don't mess with her. Wow, okay. So, the house, yes. Like, if I saw a house like this on a real estate site like this, it's a red flag to me. I love looking at houses. It's this weird little hobby I have. I just love looking at houses. I've done it like my whole life. I'm always just looking at them. And for me, the toilet seat being up is just a no. Don't do that if you're a real estate agent. Sorry about that. Make it look pretty. Put it down. Okay. Yes. And then this as well. All the pictures so far. Like, can we get to the pictures of in the house? Now here, you can see the lounge. I wonder if this is like, here's the kitchen area. The floors, they tried. You can see they tried to clean before making these pictures. But it looks hectic still. There is poop on the floor. It looks probably like cat poop, right? There were cats in the house. Do we know it's cat poop? No, we're not there to investigate, but it looks like it. Artie. Oh, man. Marjorie says she admitted to throwing stuff, guilty, intent or not. We'll talk about all this, yes. And Peter Pronzo, Harlem Raiders. If you haven't checked out the Harlem Raiders book, check it out. Hung or guilty of the lesser charges. No money on this. Better off playing the ponies. Right? This was quite a case. I wasn't quite sure how it would go when I first started covering this, but damn. Okay, so here they cleaned this up very nicely, you can see. Wow. I don't know if you guys are on TikTok, but there's those TikTok videos as well where they show cleaning up like hoarder houses. I just love that stuff. Just looking at all the cleaning. So there's the trash bag, some of it. Of course, this is now from April 2023 is when it's sold. 3-bed, 2-bath. So this happened in October of 2021. And he died in March of 2022. Yeah. Okay. And here is one of the rooms. Trying to see, here's like a lot of, are those cans? Oh yeah, there's cans everywhere. Interesting. Whose room is that? Maybe it's his room, I don't know. Oh, but the sink, man. Oh man. Now, this is where my argument comes in, is that she did know what lie could do. Initially I thought maybe she didn't, because she's like 18, we don't know what lie is, but she was the one to apparently buy the groceries. Right? Maybe she bought the lie, and maybe she knew what it would do or saw it bubble or something because of cleaning the sinks the whole time. Because they said there was, Kayla, the friend, right, said there was vomit. Like, in the bathtub, in the basin. Like, ooh. So, I just wonder if there is, that's why I wish she testified, if there was a history of her using lye to clean up these clogged basins from him puking, you know. Jennifer says, yes, poor cats too, indeed. I'd never let my kids live like this, or my kitties. I know, right? Kim Crandall says she needs to serve prison time. What an absolute horrible thing to do to a parent. Okay, so we're going to get to some debates. So here's another picture. Okay. I don't know what's going on with the towel here. It's so dirty. Damn. Really odd way to try sell a house, like taking these pictures. Maybe they're showing the state of it. Yep. Yeah, oh yeah, it was the sister. The sister and the friend Kayla look kind of like, yeah, it was the sister, saying there was vomit in the sink and shower. Thank you, yes. And Where the Wind Blows says that's from the dad puking drunk. I mean, it sounds hectic. It is like horror house, right? But it was her choice to live there, although it was a choice from around age 12. So that's interesting. Then I want to know, well, what happened at the other house? Why do you want to live there? Do you want to live there because A, you feel sorry for him and everyone's abandoned him and you want to look after him? Although it was her and Austin that lived there. The two adopted kids chose to live with him, right? Interesting. Okay, so do you want to live there because you don't want him to be alone, you want to take care of him? Or do you want to live there because there's less rules there, because he's not even able to set rules even for himself, right? What would option 3 be? Or, no, option 3, do you want to live there because the other house is so bad, right? So many ways this could go. Is this like alcohol again? I'm not sure. There's like a lot of beds with drinks right next to it. Okay. Oh man. Like this picture. You say basins are yellow like that because it was a color scheme? Are you saying that this basin is the color scheme? Like half of it white and some of it gold? I don't know about that. Yeah, the condition of the house. Okay. What is this? Yeah, put the seat down. Put it down. Okay. We're almost through the pictures. Mm-hmm. Yeah, that's what I'm thinking. Crystal answered, do we know if the house was always like that or did it gradually get bad since she was 12? That I don't know exactly. Caroline says baked and passed out parenting means the kids are freer to do whatever. Exactly. That's what it could be as well. So yeah, those are pictures of the house. So thank you to Diane for sending that to me. Alright, now let's move me over. I'll monitor the stream. I mean, we don't know. Maybe they come back within 15 minutes and they're like, you know what? We know what to say. And then we're all like, what? Okay, so let me go through my notes in a second. Just hold on one second here. Okay. So what I've written down are some factors to consider. Number one, a lot of people are like, well, she said that he is her best friend, and like, what kind of loving daughter acts like this? And I get it, but just remember, it's not her real dad, if you know what I mean. It's her dad. He raised her, raised her. I don't know how long he's been like an alcoholic, if that is the case, but her and Austin are adopted, right? And they chose to live there, and that's interesting to me. I wonder what the other house was like. Why did you choose to live there? Is it because you wanted to be freer, right? She, as I say, chose to live there from around age 12. Reason being, we don't know. Also, I think maybe, and I'm just sharing opinions, okay? I rarely share opinions, but there's many, opinions have been flying in this case, left and right here, so I'm just delicately sharing some thoughts that I've had along the way. So, the thing is, with the mother saying, you can choose. I mean, at age 12, you can choose. And then to let them go live there, let your kids go live there. You know, in a, let's say, alcoholic hoarder's house where you know they might be neglected. Even if they're going to be naughty, it can't go well. You know, it can never end well like that. But if she went to live there out of like empathy for him, then, well then, yeah, you can't throw a tantrum. If she chose to live there out of empathy, she can't then throw a tantrum and be like, what the hell, he's not up for my birthday, because he won't magically one day change, right? Okay. Damn, cobalt blue, that's a question and a half. Okay, now, the next thing is that she was very committed to going to that party. Of course, it was a very big deal to her. She just turned 18. Okay, it was her 18th birthday party. She could not have the party at the house. Of course not. We could see. And we can hear why. So, she had to like save face around her friends, number one. 2, 18, very important birthday party. Okay, and she was going to go there. Why did she not go to the hospital when she heard that he had chemical burns? I just, in my personal opinion, don't think she understood the gravity of those burns. She probably thought, oh man, like, what now? Which makes me think, well, what now? Is there anything else that happened before? Has CPS ever been involved? You know, or the police or anything? Because someone mentioned in chat as well, the police said, well, this is, you know, they mentioned something from the past. Where are those records? Are there records? Do they investigate that or not? Kathleen R. said, did mom say 2 of you have to move? Do you 2 older kids want your younger siblings to go? Manipulation? Speculation? I don't know. It's all quite interesting. Okay? And as I say, yes, everyone, you're welcome to your opinions. This has been a very debatable case. Very spicy debates happening. Just keep it friendly. Okay? Keep it chill. If you can, please. That would be nice. Because we're all here together. Okay? So... Dr. Patrice Berry says exactly. I think she was trying to hurt him, but not kill him. Right? Okay, so then she was so set on this party that when the credit card didn't work, like she was so committed to it. She sent her friend over there, like, just go over there, man. The pin isn't working. Her friend goes over there. So someone in chat said, how do we know that the friend didn't pour water on him to wake him up? Like, wake up, like, hello, like, we need your pin, dude. But at the end of the day, it seemed like he didn't wake up, right? She looked at him and he's like, damn, he's got so many burns, or his skin looks blackened. And then what happened? The prosecution actually made an interesting point. That neither Kayla nor Austin nor Megan called 911 or the ambulance or anything, right? Austin said they should. But it wasn't like, oh my word, like immediately call 911. In fact, it was Dave the nurse who reported the domestic assault on the patient. So that's interesting. Yeah, this is the thing. Joe Kelly says, but if everyone is telling her that she burnt the heck out of her dad, why doesn't she get upset and want to see him? Wouldn't you want to see for yourself? Possibly, yes. But it depends on the history as well of that. How many times did it happen? You know what I mean? It's interesting. We actually need a lot more evidence in this case, of course. Then, yes, as I've speculated, I think she may have known what Lai did. She said to the police, well, I didn't know only powder would do that. And they said, but you said you threw a bottle of water too. But now we don't know. I wish we knew more. You know? Did she throw the water after the Lai? How do we know she didn't throw water on him to try wake him up and then put the Lai powder on? I know there was a reaction, but the reaction could have also been from urine, as you guys have said. It could be from showering or anything else. Okay. So, but do we think that she knew what Lai did to skin, I don't think so. But did she know it was maybe bubbly, caustic soda? Yeah, maybe, because she was probably possibly cleaning the ooh. It's so gross to think about, like the clogged basins and showers and stuff. Then, it's interesting to me that Austin, yes, was so defensive, you know, and angry, but mostly also because he kind of banned everyone from seeing his dad. That was interesting, because he's like, the ex-wife, so his mom then, wasn't allowed to see Konrad. Megan wasn't allowed to. Morgan wasn't allowed to. Like, it's not just like, you know what, you could all see him, but Megan may not because she did this to him. It's like, none of the women may. That's just something to note. I don't know what gravity that holds, but it's just something to note that I found quite interesting. And of course, he's in denial about his dad's drinking, because the dad says, well, I just had a Smirnoff Ice. I mean, he makes as if he didn't even finish it from the night before. He woke up and finished it. A Smirnoff Ice, we know it's never just one drink, right? Especially with a blood alcohol level of 0.255. Then, what else? Yeah, I wrote mom letting her live there, and then I would... we can't blame CPS, but we know CPS often pucks up in these cases, right? So for CPS to decide that these are the parents that are going to adopt these kids is interesting to me as well. And then I think all the lie companies must be very careful right now before they get sued. Make sure those labels are huge. What do you think? Okay, yeah, Sweetie Pie says there's more to this family. That's what I'm thinking. I'm thinking there's more to this family and more history. And yes, now what I want to say is, while it's very sad, okay, we often see, let's say, failures with CPS. We see it, okay, lots in true crime. Then we also often see trauma upon trauma for adopted kids. We've seen that before. Not always, but it happens. This is obviously a true crime channel, so I mean with the stuff we look at, right? But it still doesn't excuse doing this, right? There still must be consequences. I agree. I just don't know if it's like, I don't think it's intentional murder, and I don't think it's like life sentence, like forever in there, right? Ew, urine on his back. I don't know. It depends if he turned around, right? Rabbit says, I thought the brother... Oh, yeah. But the good point. That's what we were saying earlier. The brother did say. So why can't she go to the hospital? Well, the brother sounds quite intimidating, you know? And already saying, you did this, you don't come to the hospital. So there's that to consider as well, you know? So maybe he was the man of the house, if I could say, the brother. And really calling the shots, and even with the mother. He set the boundaries. He set the rules. He set a passcode at the hospital so that no one could see the dad except him and another individual, which could have been Kobe, right? Okay, so a nurse says, Nurse Babe, I think he wanted to protect his dad. Imagine seeing your father in that condition. Jeepsla, are you behind on the stream? Or you want to check his blood alcohol level, do you? Okay. So, Rochelle says, they read hoarders do not want anyone. Yeah, hoarders usually, like, why doesn't she... People say, why didn't she clean up? Well, it's not her responsibility, but also, maybe not everyone's compelled to, you know what I mean? She just turned 18 then. I like cleaning, so I probably would have, okay, I just would have, unless a hoarder is telling you not to. Often they do. They get in your way. They shout at you. They tell you not to, right? Also, one thing that the victim said was that we were bad-mouthing each other. And he's like, that's normal, you know, but it's not normal for the father figure to be bad-mouthing back and forth and arguing back and forth with her, right? Like, there was not much parenting going on, is what I'm saying. And this would be a consequence of all that. So she's gonna, probably pay the price of all of that. And it's her action. She took an action. But in the big picture, it wasn't like as aggressive of an action one might expect with that amount of speculative rage, right? And man, I think she's going to pay quite the price. But let's see. Candy E says, Austin didn't ring true to me. Yeah. KK says, to me, skull and crossbones means warning, toxic, don't drink. Not anything about skin. Yeah, okay, that too. Okay. Okay, so people are saying, you don't know why people defend her. I don't know if I'm defending her. We're not really defending her. We're discussing the facts because it's all actually quite tragic, huh? It's quite hectic what happened here. So yes, okay. You guys can hear me, right? Just checking. Yeah, this is interesting. Child neglect has to be a mitigating factor. Interesting. I also do think that the police arriving, there's so much that went wrong in this, in this case, in this investigation and everything, and at the trial, I think, in my opinion, right? Because even the police officers arriving there, I mean, the defense tried to make a point of this, but arriving there, it just reminds us of the Gabby Petito days, right? And I'm just saying, when they're surrounding her like that and really intimidating her, instead of saying, we need to take you in for questioning, is that okay? Rather do that. They'd be like, yo, we're here to investigate. So what did you do? You threw powder on it, right? And water, right? You know what I mean? Like, it was just, ooh. And that really cost her. So what is the lesson in this whole case? Yeah, don't talk to the police unless you have an attorney. I think that's the lesson. Yes. Oh, man. Rochelle says you should do a show on hoarding. No. Well, unless it's true crime. Like this one. Let me hear. Oh, sorry, I'm hearing again. If it's an airplane or lawnmowers, I don't know. KK says, good, listen, you love cleaning. You're welcome to come to my house anytime. So I'm guessing you guys don't want to see the body cam video again, even though I cleaned up the audio for you, because now we've seen a whole bunch of it there, and I'm guessing you don't want to see it one more time. Am I right? Yeah. Threw muffin mix. It's white stuff, right? Well, that's true. It doesn't prove that she threw lye. It's so weird how they showed the picture of the lye as well, all clumped like that. It wasn't like it fizzed up and was just dissolved. You know what I mean? It was like these clumps. And the prosecutor said he was lying face down. So if they said all the injuries were concentrated around his groin, that's also interesting. To me, it tells me he may have peed. He may have peed because he was there for quite a few hours, right? Okay. So Karen says, I do not think anyone said this is justified. Almost everyone agrees she needs to be held accountable. No, this case is not murder, but the hoarding, his alcoholism are factors. Yes, they are factors, so we're not victim blaming. Not that I can speak for everyone, but on this channel, we don't victim blame. We're not saying, this dude was a drunk hoarder and deserved it. No, we're not saying that. But there's factors to consider, which is, I suppose, the most interesting part of this case. All the factors that led up to this. Can someone just act out? No. I mean, there's most of us have been through a lot of stuff, right? And there's many factors to consider, but just don't throw lie at people. Even though, damn, there's a lot of stuff to throw around the couch, right? And where's the cap? I also want to know, where's the cap? Did they ever search for it? They should have. They really should have. Where's the top? Was it in the room? Was it there by the couch? Or was it in the kitchen? Or was it in another room? That's also interesting, right? Anna says the cops had no reason to arrest her until she said she did it. Yeah, I just feel like they really coerced her there. At 18 years old, standing there and like, oh crap. Worst birthday ever, right? For real. Rock Girl 77, thank you for being a member for 4 months. Okay, I'm going to read some of your comments now. Yes, and Jeanette says life's complex for everyone. And no, we can't just throw tantrums. We can't throw stuff at people that would be domestic abuse, which is why the charge is like that. Misdemeanor domestic violence. That I understand. That totally. Get it. Yeah, no victim blaming. Okay. Yeah, Birdie B says, no opinions here will have any bearing on the outcome of the case. There's no point arguing with each other. As Rochelle said yesterday, just roar gently. As a grizzly, just roar gently. Yes. Some rando says, you could see the lye lines on the edges where the moisture stopped. Yeah, you could see that too, and then those clumps. And it's so weird, as that little bottle too. That's interesting too. I have many questions still. It's like this little bottle, and there's still some left in it, but yet there's this big clump. And it's all absorbed into the wet area of the couch. Like, damn. Was there another bottle, perhaps? Is the question. And Vicky says Austin was the gatekeeper. I just don't know if it's appropriate, right? To be like, no one can see him. Only him and his friend, I think. I don't know. But it depends on the situation. Lorraine says, best place to be. Thank you for being a member for 20 months. Oh, my word. Lorraine, you're an OG. You've been here from the start. Yeah, Jeepsler says, how much he drank, not at issue. She threw it. I can't stand an alcoholic. I was raised by 2, but get the issue right. Exactly. It's a factor, and it can make people really, really mad. Neglect can make people really, really mad. But it doesn't mean you can throw anything at anyone. You can't bite them, hit them, throw things at them, abuse them. Just leave then. And that's what bugs me, is she was able to leave. That's what really it comes down to for me, is she wasn't forced to live there. She could have gone and lived with her mom anytime, unless that's not true. But it seems like it. The mom's like, I gave them a choice. Okay, but was that choice then binding forever? Like once you choose, that's it? Or what? You know what I mean? Could she not go and live there? If it's by choice that you're living there. Yeah, even more so, man. then you should never act out like that, but don't anyway, right? Move out. Caroline says, yay, Grizzly, and her comrade kitty cat Fury. Yeah, I don't know where he is right now. I think Fury's lying outside in the sun. Nana. Banana. In Havana. Thank you for being a member for 2 months. Okay, last few comments, and then I'm monitoring the stream. We'll see what's happening, but there's a lot happening in true crime today. So please make sure you are subscribed with the bell on, because I'm probably going to go live with something later. I really still want to talk about Taylor Shea business. I want to talk about Corey Richards. I want to talk about Lil Dicky. Sorry, that's Richard Allen, Delphi. If you know, you know why we say that from presentations. But he's now in court, and the court did say they're not streaming the proceedings. Okay, but I'm monitoring. That's why I'm looking here the whole time, because I'm looking at Twitter. If you're not on Twitter yet, please come and join me on Twitter. My handle is @TrueCrimeGizzler. Please don't get caught out by the freaking impersonator @GrizzlyGizzler. That was my old handle, surprisingly. When I changed it, oh, someone took it and they are now impersonating me and continuing to say they are not impersonating me, but they are, and they are DMing people pretending to be me. That's weird. Stop it. So mine is @TrueCrimeGizzler. Okay, I'll be on there. I'm following all the updates here. So there definitely will be something else happening later today. For now, I hope we'll actually be back later, but I don't think so. I'm thinking we could be back tomorrow with this verdict. Yes. Okay, let's see. Last 5 comments. Yeah. Flummoxed Fossil says, have you ever had emotion so intense you cannot see anything? I have, but still, you can't harm others, right? But we all know I think we all know what it feels like. Maybe we don't all know. Some of us know what that feels like. Yes. Deborah says, the testimony from the mother was that she decided to live with the father. Exactly. She chose to live there. So if she's choosing to live there, but then throwing tantrums about him neglecting her, him being a drunk, him being a hoarder, all this, you know what I mean? Like, but you chose it. And you actually then chose it every day because you still chose to live there. And why? We don't know. Okay, Gaynor says, I think she should be punished enough to know that actions have consequences, but life in prison, no. She has to live with this for the rest of her life. Agreed. And I mean, I don't know if it's just like not guilty, just off you go. I'm not sure if that's the right thing either. That will set quite the precedent, right? Imagine all the other teens in the area too be like, oh cool, we can just like throw lie on our parents if they neglect us, or if they can't get up to drive us to our party. Whoa, okay. No. So there will be consequences, I think. There should be. Life in prison, I don't know about that. Depending on when she's eligible for parole. Amanda says, Mom should have seen what was happening and removed them from this unsafe home. Interesting. Yes. Last one. Let's see, one good one. Oh, okay, that's interesting. Rose with Thorns says, probably expensive and time-consuming to swap custody. So they could have told her to stay until she's 18. That's true as well. Yes. And that's true as well, Michelle. So thank you all for your commentary. I hope you leave some comments below. Don't be too feisty now. Keep it grizzly, okay? Let's not fight. Don't fight with each other in the comments. Mostly in this community, we don't do that. So don't go Barney over there, okay? If you haven't yet subscribed to my second channel, there's some comedic relief for you over there, which you might need after days like this. Otherwise, yes, I will see you later with something. One of those things I mentioned. There's lots going on in true crime right now. So, see you then. Stay safe. And thank you again, moderators. Thank you to all my patrons. It's because of you that I got a new graphics card. Thank you, patrons. I really, really appreciate it. And everything seems sorted. Bill Gates likes my new graphics card. Okay, Bill Gates. And thank you also to my members. All right. See you in the next one. Bye.